Hello, my name is Adam Diamond, and I'm an agricultural marketing specialist in the enforcement branch of the Packers and Stockyards Division. PSD is part of the Fair Trade Practices program within the USDA's Agricultural Marketing Service. This webinar provides an overview of a new proposed rule called Fair and Competitive Livestock and Poultry Markets that was recently published by the USDA in the Federal Register, with a 60-day comment period closing September 11, 2024. This webinar presentation is intended to provide an easy-to-understand overview of the proposed rule. We'll start by discussing some background and history that led to the development of the rule, and then go on to describe the need for the rule, USDA's legal authority for publishing the rule, and an overview of the rule's provisions. The authority for this proposed rule comes from the Packers and Stockyards Act of 1921. Section 202 of the Act includes a prohibition on any unfair, unjustly discriminatory, or deceptive practice or device, but it did not define unfair practices. This proposed rule defines unfairness under the Act for the purposes of USDA enforcement. Congress granted rulemaking and enforcement authority to USDA to ensure that appropriate market protections are afforded to those participating in livestock, meat, and poultry markets, so as to ensure a competitive and fair trading environment. Prior to this proposed rulemaking, USDA administrative law judges and the judicial officer decisions in Packers and Stockyards Act enforcement cases made on behalf of the Secretary of the USDA have constituted most of USDA's interpretation of what unfair means under the Act. Historically, the USDA would examine specific conduct and bring cases if the alleged violation was among those practices Congress designed the Act to prevent. This case-by-case approach has led to uncertainty about what unfair practice or device under 202A of the Packers and Stockyards Act means. Congress drafted Section 202 of the Act to reach a range of unfair practices and devices, such as anti-competitive practices, market abuses, or other distortions of the competitive process. Congress granted rulemaking and enforcement authority to USDA to ensure that appropriate competitive and fair trade and market protections are afforded to those participating in livestock, meat, and poultry markets. Furthermore, congressional passage of related fair trade statutes supports this proposed rule. In 1914, Congress passed the Federal Trade Commission Act. In 1938, Congress disapproved of a narrow judicial interpretation of the FTC Act and passed the Wheeler-Lee Act, which clarified the expansiveness of the FTC's unfairness authority by specifying that it covers acts or practices that injure consumers, regardless of whether or not such acts or practices cause injury to competition. Notably, the Wheeler-Lee Act was itself modeled on the P&S Act's Section 202A's prohibition on unfair practices that injure producers, applying it to consumers instead of producers. Congress enacted the Packers and Stockyards Act to promote fairness, reasonableness, and transparency in the livestock, meat, and poultry marketplace by prohibiting practices contrary to these goals. From the plain language of the text, Section 202 of the Act is broader than the antitrust laws and does not necessarily require harm to competition as that term is understood under the antitrust laws. USDA recognizes that some courts have recently required proof of competitive injury before finding that conduct is unfair. These courts were not offered an alternative definition for unfair, which this rulemaking proposes. A competitive injury requirement cannot be imposed in a way that nullifies part of a statute. To the degree requiring a competitive injury precludes finding conduct is unfair when it satisfies criteria in the proposed rule, such a requirement would unduly limit the reach of Section 202A and is improper. In this proposed rulemaking, AMS proposes separate comprehensive rules with specific tests to protect both market participants and the market itself from harm. It has always been USDA's position that it is not necessary in every case to demonstrate competitive injury in order to show a violation of Section 202A. But USDA has also consistently recognized that any act or practice that harms or is likely to harm competition also violates the statute. This proposed rule provides a basis for the public to understand precisely how USDA would apply the statute to both categories of harms: those that harm or likely harm market participants, and those that harm or likely harm the market. USDA recognizes that some conduct and practices may produce harms that qualify as unfair under both categories, i.e., they cause harm to individual market participants and they harm the market by lessening competition. For this proposed rule, USDA employs an analytical structure similar to that presently used by the Federal Trade Commission to determine if business conduct is an unfair practice. USDA is proposing a rule that would find a practice to be unfair if it causes or is likely to cause substantial injury to one or more market participants, which participants cannot reasonably avoid, and which the regulated entity that has engaged in the act cannot justify by establishing countervailing benefits to the market participant or participants, or to competition in the market that outweighs the substantial injury or likelihood of substantial injury. All three of these elements must be met for a practice to be unfair. The application of these three elements, when combined, explains the outcome of a great many of the cases brought under the P&S Act and provides a clear and workable standard for adjudicating many kinds of unfairness claims. Furthermore, as shown on the next slide, the proposed rule sets forth several considerations that the Secretary of Agriculture may use when applying the proposed tests. This proposed rule is intended to explain those instances where likely or potential harms to producers would rise to violations of the Act and sets out factors or criteria to cover that broad scope. The proposed rule includes consideration of the extent to which the practice may impede or restrict the ability to participate in a market, interferes with the free exercise of decision-making by market participants, tends to subvert the operation of competitive market forces, denies a covered producer the full value of their products or services, or violates traditional doctrines of law or equity, or the extent to which the producer would have to take unreasonable steps to avoid injury. An injury is not reasonably avoidable solely because the practice has been disclosed. A market participant would also not be required to take unreasonable steps, such as exiting the market or making unreasonable additional investments or efforts to avoid the harm. Additionally, the USDA may consider the potential magnitude of the injury, whether that be significant harm to one market participant or small harms to many market participants. Unfair practices are not only those that injure producers, but also those that may negatively impact competition because they injure or tend to injure competition or competitive market conditions. AMS takes the position in this proposed rulemaking that harmful methods of competition under the P&S Act are similar to the practices that the FTC and the courts have long recognized as either anti-competitive or unfair, collusive, coercive, predatory, restrictive, deceitful, or exclusionary methods of competition that may negatively affect competitive conditions. Conduct would be considered unfair under the proposed rule if it harms competition or has the tendency to negatively affect competitive conditions, impairs market participants' ability to compete, or reduces the likelihood of potential or nascent competition, notwithstanding that it may or may not yet have done so. Furthermore, as seen on the next slide, the proposed rule sets forth several considerations that the Secretary of Agriculture may apply when assessing the proposed tests. Because the courts have been clear that behavior that is likely to harm competition violates the P&S Act, AMS proposes standards with respect to injuries that are likely to harm the market. These proposed standards include: 1, the extent to which the practice impedes or restricts the ability to participate in a market, tend to subvert the operation of competitive market forces, interferes with the free exercise of decision-making by market participants, violates traditional doctrines of law or equity, or has indicia of oppressiveness, such as evidence of anti-competitive intent or purpose or absence of an independent, legitimate business reason for the conduct. And 2, the extent to which the practice tends to foreclose or impair the opportunities of market participants, reduces competition between rivals, limits choice, distorts or impedes the process of competition, or denies a market participant the full value of their products or services. The Fair and Competitive Markets for Livestock and Poultry Markets proposed rule, if finalized, would clarify what unfairness means under Section 202A of the Packers and Stockyards Act. Unfairness covers harm to market participants and harm to the market. The proposed rule is intended to facilitate fair trading practices as required by the Packers and Stockyards Act. All comments submitted in response to this proposed rule will be included in the record and will be made available to the public. Please be advised that the identity of individuals or entities submitting comments will be made public on the internet at the address provided in this slide. Parties who wish to comment anonymously may do so by entering NA in the fields that would identify the commenter. You can scan this QR code to view the rule. You also can go to the website below. Thank you for joining today's webinar.